Hi, and thanks for joining me. Welcome back if you are a regular viewer of the channel, and welcome if you are new. My name is Peter Lamont. I'm a New Jersey business and litigation attorney. In today's video, we're going to talk about expectations. And expectations are important when you're dealing with legal matters, but let's just take a step back here and talk about expectations in general. So I'm a big believer in having high expectations for yourself. Never settle. Always push yourself beyond what you think you can do, and to expect more from yourself than anyone else does. That's how I hold myself out. It's what I teach my kids. So having those expectations, unreasonable expectations of what you can do, what you are capable of, and then doing the best you can to achieve those unreasonable expectations is very important to me. You know, when I tell my kids about setting goals, I don't tell them to set a goal that's one step away from where they are. I tell them to set a goal that's 20 steps away from where they are. When I deal with clients, especially business clients, maybe somebody who started a new business and they are coming to me for business consulting and advice on marketing and advice on maybe product design, things of that nature, I tell them, shoot for the stars, have high expectations and expect more from yourself. All right, that's personal development. That is business development. Those expectations that I'm talking about, those unreasonably high expectations, they do not mix with litigation, right? What's litigation? Litigation is a lawsuit, whether you're being sued or suing somebody. In litigation, those unreasonable expectations only hurt you. Here's why, and here's what I mean by that. When you are being sued or suing somebody, and in this example, let's say you're suing somebody, you believe that you are entitled to $100. And we're just going to keep this simple, obviously. Of that $100, you expect to get back all of it. And if you're someone like myself who has these unreasonably high expectations, you go into a litigation or a lawsuit and you say, damn it, I'm going to get $100 back. As a matter of fact, I should get more than $100 back. I should get $100 back plus what I have to pay my attorney. I want my attorney's fees. So you are setting these unreasonably high expectations. And while it's going to work for you in business, it's going to work for you with your kids, it's going to work for you with your husband or wife, your significant other, it's not going to work here in litigation. Because here's what's going to happen. You sue, and the other side turns around, and they have all these reasons why you're not entitled to your $100. Forget about the attorney's fees for a moment, because unless you've got some statutory argument, or the case is a fee-shifting case, or there's some contractual provision for reimbursement of attorney's fees, those are out the window. So you've got this adversary that is going to do all they can to not pay you the $100. They're going to say you were at fault. They were going to say you knew or should have known. You have partial responsibility. They're going to say and do all they can to deny that they owe you any money. So now you are at opposing points, right? You couldn't be much further apart. You say you owe me more than $100. They say we don't owe you anything. And sometimes you're going to get a defendant that counterclaims against you. And so now that defendant is saying, not only do we not owe you money, but you owe us money. All right. Now, when you have unreasonably high expectations, you make it nearly impossible for yourself to resolve a lawsuit. 99 1% or so of all cases end up settling. When you have unreasonably high expectations of the outcome of your litigation, you will be that 1% that says, I'm not going to settle. And you know what happens? You overspend on legal fees. And oftentimes you end up getting nothing or breaking even. But in most cases, when you are unreasonable in your expectations and thereby refuse to settle, you'll end up overpaying. Now, should you settle every case? Of course not. No, there'd be no trials if everybody settled. But there are times when you need to take a case to trial, but not all the time. Not 99.9% of the time. Or maybe I was a little overzealous, 99% of the time. That 1% is when you take the case to trial. But most of the time, you're going to be looking to settle. So your unreasonable expectations, out the window. You've got to go into litigation doing your best to get the most, but understanding that you might not. Understanding that there are factors at play in litigation that are outside of your control. What your adversary does, what the court does, what a jury might do. And you have to remember that it all costs money when you're litigating a case. Sure, you might say, well, wait a minute, what about contingency? I'm not talking about personal injury cases and contingency lawyers. I'm not talking about that. I'm talking about things like business disputes, where you're going to sue a business, and it's business to business, or contractual obligations that you're disputing, or partnership, or any of those things where you're not working on a contingency arrangement, because that's a completely different animal. When you are suing somebody on a business matter and you're paying hourly and you've got those unreasonable expectations that you're going to recover $100 plus your fees, remember, we're trying to keep this simple. So obviously these numbers are not what you would pay a lawyer and not what you would hire a lawyer to sue for. But let's say you pay your lawyer $25 and now you go and you make some progress in the case as far as things that are done, but you're out of money. Now the case progresses, you need to replenish that money. You need to replenish that retainer. So now you're $50 in the hole. Let's say the other side doesn't want to settle. Let's say they're fighting you tooth and nail. So now more money, another $25. You're getting to the point where you're almost at $100, which is what you're hoping to recover. How does that make sense? It doesn't. What makes sense is pay your lawyer $25, try to recover as much of the $100 as you can, and then be open to the possibility of settlement. Because if when you sue that person, they respond, let's say that they deny everything and they don't owe you anything, they're still likely going to settle because they don't want to have to spend $100 on their lawyer. They would rather say, look, we'll give you $50, $75 of the $100 that we owe you just to make this go away, because they know that they're going to have to pay their lawyer. What this all means and why we're talking about this today is because unreasonably high expectations of yourself, unreasonably high expectations of your business, that's fine. But unreasonably high expectations of outcomes in an unpredictable litigation, not fine. And it's only going to lead to disappointment and frustration for you. And I don't want to see that. So be open-minded, okay? Shoot for the stars, but have an understanding that in litigation, you need to be cognizant of what you're spending on your attorney, what the likelihood is that you're going to recover, and be willing and open-minded to the possibility of a settlement. All right, that's going to do it for today's video. Thanks for joining me. I'll see you next time.